Good morning, Lauren.
Morning.
How are you?
Great. My Dodgers won the World Series last night.
Heck yeah. Heck yeah, man. I was jumping up on the table last night.
Me too. I definitely cried.
Wasn't that great? Oh, man.
Great feeling.
And the way it happened too was awesome. Just
Yeah.
did he strike out the side? He struck out the whole side, huh?
Yeah, he did. He did
Yeah.
it in an inning too. He was on top.
Unbelievable. Yeah, I'm so glad for everybody, all of those Dodgers. I mean, I remember staying up until 3 o'clock in the morning a couple years ago against Boston in that game that went, what was it, like 18 innings or something.
Yeah.
And then, the Houston series. And then to find out that they cheated, and,
Yeah. The
and all of
commissioner of
that.
baseball was when he was presenting the awards, he was getting booed.
I mean, the Dodgers so deserved, especially after that cheating scandal.
Yeah.
But like Kershaw, I'm so glad for him because
Yeah, I'm really for him too. He's the main person I'm really happy for. And
yeah.
Tommy Lasorda and Vin Scully too.
Oh, Vince Scully too. Yeah, yeah. Although Vince Scully has seen, he's seen a few of them.
They're just they're not getting any younger. They're getting really old, so at least they got to see another World Series championship.
Yeah, yeah. All right, Dodgers. Now we gotta pull for the Rams. I don't know if you're a Rams fan, but
Yeah, half of my family is Rams and half of my family is 49ers.
oh, okay, okay. Yeah, when it comes to football, because we haven't had a team for so long in LA, it's kind of a lot of LA people are attached to other teams.
Yeah.
But okay, I'm going to get started. Today, I am going to talk so many things that are part of ethics, especially in graphic design, but in business in general. But in graphic design, there's a lot of things, ethical questions that come up. In fact, we used to give a book out called by the Graphic Design Guild called Graphic Design Guild Pricing and Ethical Guidelines. And it was kind of ethics in relation to how we price work, how we price our service, how we price, our time. And it was a good book. It was a good guide to give you an idea of about what people are charging. But it was written in New York, and New York is, their pricing is much more than, you know most of the country, and so it wasn't exactly relevant. And then pricing is something that it's always changing, so it's it's hard to kind of keep current. I think the internet is probably, the best place to keep current these days. But that's an issue, and that's an issue that we're going to talk about and address in another lecture. But today, what I want to talk about is the ethics of, well, I've titled this lecture, and let me just share my screen here. I've titled this lecture Inspiration versus Copyright Infringement. And copyright infringement is something that is definitely an issue that we as graphic designers will face. Whether it's with our own clients or whether it's from companies that we work for, employers, superiors telling us what to do, telling us what they want. I'll actually show you some examples of that being the case. And a lot of times it's very difficult to look your boss in the eye and say, no, we can't do that. That is copyright infringement. And then your boss coming back to you and saying, well, look, you want to keep your job, you do what I ask. Okay, otherwise, go look somewhere else. So that's a lot of times, we're faced with that dilemma of should we or shouldn't we? And I will definitely tell you, you should not, because the last place you want to be is in court. and being sued and having to pay attorney's fees to represent you. Not that it'll ever get that far, but if you're working for a company, there is a possibility that that company could get sued, depending on how far they want to take it. Anyway, I want to show you some examples of that. I want to bring up but I also want to explain what the difference is between being inspired by something and doing something similar to what you see. Because, I mean, let's face it, everything that we do has been done before. Every layout that you could possibly imagine, every combination of elements that you put together has already been done. All you have to do is just Google it and you'll see a zillion similar type things that you've just created that you think was, the most unique and original thing you've ever done. That's kind of the sad part of it, the disappointing part. But anyway, I want to talk about this idea of copyright infringement. And first of all, we have to understand what is copyright. And copyright, and we can talk about this until the end of time. And again, this is a huge subject. Copyright attorneys fall under the realm of what's called intellectual property. And intellectual property is just simply property that you own, whether it's a work of art or whether it's a, whatever it is that you have created by, and that you own that. And by that, you own the copyright. So to define this simply, we could say that you own the copyright once you've created it. Now, you can copy something that somebody else did. In other words, I can take my camera out to the Golden Gate Bridge and I can shoot a picture of that bridge exactly the way, some famous photographer did. But I created that photo. It came out of my camera. I pushed the button. It's my photo. Now, whether it looks like someone else's photo or not, that is debatable. And so another thing to understand is that copyright infringement, copyright laws are very gray in terms of, it's not a black and white issue. There's a lot of factors involved. But I want to kind of simplify this down for us so that we don't get into such a gray area. Basically, if you've created it, you own the copyright. Now, trademark and copyright are different things. You'll see registered trademark. But copyright, the circle C, is simply the ownership rights of that work that you created. So, in terms of what we do as graphic designers, and an example might be that you're creating, an advertisement or, whatever graphic you're creating, a poster. If it's only copyright infringement if you use elements or just flat out used, the main element of somebody else's work without their permission. So the best way to describe this is to give you a case study of this. And I'll try and be as brief as possible. Also, I found out that I talk very slow, and I apologize for that, especially in this day of, sped up stuff. You can always speed this up on YouTube. I was listening to myself at 2x speed, and I was like, yeah, that's probably the way I should talk these days. But anyway, the case study that I want to relay is one, it was a lawsuit from Annie Leibovitz, the photographer. If you're not sure who she is, she's a very famous photographer. She's done a lot of photos for Vanity Fair magazine. She sued Paramount Pictures for a photo that they used for a movie called The Naked Gun 3.5 or something. Anyway, as the story goes, back in 1996, she took a picture of Demi Moore, the actress, and for Vanity Fair magazine. And Demi Moore was pregnant. She had a profile picture, and it was the cover of Vanity Fair. And it was, very controversial at the time, because she was pretty much naked from the top down, but it was a side profile. And she was kind of holding her belly. And anyway, that became a very famous cover for Vanity Fair magazine. Okay, shortly after, Paramount Pictures used Leslie Nielsen, the comedic actor, in a pose exactly like Annie Leibovitz pose of Demi Moore. And they had hired a model and they shot it in the studio and they superimposed his face on the model's body. And he's looking at the camera in the same way, but he has this kind of comedic smirk on his face. And Annie Leibovitz saw that poster and they sued Paramount Pictures. And Paramount refused the cease and desist letter. If you're not sure what a cease and desist letter is, it's just simply a letter that if a company feels or a person feels that you infringed on their copyrights, they will send you a letter to stop publishing or stop distributing and take things down, basically. And if you don't, it's a kind of warning letter to you. And if you don't, they will threaten to take you to court. And they usually give you a time frame on it, a certain deadline to have all that done. And that can be just absolute disaster for a designer or a client, especially if you have a lot of things out there that you've already done, like a logo that's been put on, all kind of things. So you have to be uber careful when you're creating graphics that you're not infringing on copyrights. And the best way to do that is just create it yourself. And we'll get into the details of that. So anyway, let me show you this picture. Pull this up. And this is the original Annie Leibovitz shot of Demi Moore. This is the reproduction for the poster. Now there was lots of type right here. I think there was other forms of type up here, but basically, it's the exact same thing. You got the ring thing going, you got the hand posing. Now the one thing that was different about this that you might not see in this is that this is a different model. This is not Demi Moore. This is not a copy of this photo. You can see the dimple here. You could just see, if you look very closely, you could see that this is not, Demi Moore's body. But it's pretty darn close to, in terms of the pose and so forth. Anyway, if you're interested in reading this case, go ahead and Google it and you can read the case and you can read, what the result of this case. Well, I'll tell you what the result of this case is. Now, on first examination of this, you would say, okay, that's copyright infringement. You can't do that. You can't use a photo of her. Well, what they found out is that it was not her photo. It was not a photo of her photoshopped or doctored. This was an actual model that they had hired. But they still continued on with the suit. And, in defense of Paramount, very briefly, what they said was that the lighting was different, the expression on his face was different, even the ring was different in terms of, its sparkle and its emphasis and things like that, where this one was a little bit more subdued. She has a much more serious expression. He has this kind of satirical expression on his face, and so forth and so on. Anyway, long story short, the result, the award went to Paramount Pictures. And they basically said that this is not copyright infringement because, number one, first of all, and the most important part of all of it, was that it was not her body. And then they went into all the other aspects of it. The lighting was different and, so forth. And so the lesson here, the takeaway, is simply that you cannot use another person's work, and you cannot use their work and doctor it in programs like Photoshop. So that's kind of a myth that people have when it comes to copyright infringement. Can you use someone else's artwork and change things up? In other words, can I go in there and just swap out a head or do something like that? The actual law to that, and this comes from a seminar that Carly and I went to many years ago at Cal State San Bernardino. There were two intellectual property lawyers that gave a seminar on copyright infringement in relation to graphic design. And that was something that, we encouraged all the students to go to. It was put on by the Art Directors Club of in the Inland Empire. And these two lawyers referenced this case here, the Demi Moore case. But they also said that copyright infringement is utilizing somebody else's work or using that work and modifying it. And there's a legal term that they use in copyright infringement called substantial similarity. And that's what they're looking for. They're looking for what's similar to the original rather than what's different. And that's the myth that you want to debunk, is the fact that it's not what's different, it's what's similar. So if you can detect, the other person's work in your work, that could be points for your side. Now that doesn't mean you're going to win the case, but that like I said, this is a very gray area. And in copyright infringement cases, both sides are just trying to rack up points, and whoever has the most points at the end wins. So there's valid arguments on both sides. But the main thing, like if this was the Demi Moore photo and it was photoshopped, then Paramount would have probably lost. At that time, shortly after, there was a commercial put out by Taco Bell, and they used, and this is another example case study that these lawyers used. It was a Chihuahua that they used. And I don't know if you remember this, it was quite a while ago, but this Chihuahua went around saying something like, "Yo quiero Taco Bell." And it would just kind of run around, and it was like, "Yo quiero Taco Bell." And so, it was a success. It was a big hit, and it generated a lot of sales for Taco Bell. Well, Der Wiener Schnitzel came around not long after, and they used a similar Chihuahua. And I don't know what it said, but it was kind of a direct parody of or copy of the Taco Bell commercial. Anyway, again, they sued, Taco Bell sued, and they lost the case because it was not the actual Chihuahua that Taco Bell used. So it was not their property. They used another Chihuahua, and it was, So what does that say? It says that the idea, a concept, cannot be copyrightable, is not copyrightable. You cannot have an idea that's copyrightable. It's property. It's physical property that you're talking about. So, if you think of an idea and someone else thinks of that same idea and you both implement it, no one can sue anybody else. Another thing that's not copyrightable is a layout. In other words, how you arrange things on a page. Okay, this is centered. Text is going across the top, blah, blah, blah. Layouts, there are so many layouts. And you have to understand, if you've ever been in court, really, court is a very gray area. Sometimes it goes this way and sometimes there's equal and opposite arguments. Judges understand, juries understand that things are, they're not black and white. My brother's an attorney, and he's told me that for years, that life is not a black and white situation, no matter how much people want to make it that, whether it's the media or whatever. It's a gray area. We live in this gray area. And the fact is that there's so much content out there today that you can't possibly copyright a layout, because you would be suing left and right. A layout is just simply the elements on the page, how it's done. So if I did the exact thing of this, if I laid out a magazine in the exact, uh, you know, unless it would only be copyright infringement if I use this photo and I use this typography that, let's say, Vanity Fair had a designer design specifically for them. If I ripped off this type, that would be copyrightable, copyright infringement because they own it. Okay, but if I use a typeface that looks just like that, but it's not Vanity Fair's, I can get away with that. That's fine. There's nothing wrong with that. I always tell students, copy to your heart's content as long as all that information is yours. Okay, you own the rights to that. If you don't, then you're liable for, a cease and desist letter or possibly a lawsuit against you. Typefaces on your computer are all fair game to use. Photographs that you take from your camera are all fair game to use, but just be real careful. In fact, I don't even want to say be careful. I just say do not use images that you do not have permission of. And that's a Google search. That's downloading anything from the web. You are liable to get pinched for that. Now, what are the odds of you getting caught, if you will? Probably for most of us and for most of what we do, probably very slim. Maybe the odds of you getting an audit by the IRS, but it's still possible. And normally what will happen is you'll get warned and through a cease and desist letter. And you'll have the opportunity to correct it before, you have to hire lawyers and show up in court. But you want to kind of avoid that at the get-go. And definitely whenever you're doing work for a client, you really want to make sure that what you do for that client is clean. And you're not using any kind of copyrightable material inside of that work. Now, there's this term called derivative. And what is a derivative work? And that's another term that I think all of us graphic designers need to know. We know what an original work is, but now we need to know what a derivative work is. And a derivative work is just simply, to again, make it simple, is a piece that you create in your own creative way, but you're using pieces of copyrightable material. Okay? So just because you're not using the whole thing doesn't mean that it's still not copyright infringement. You can do a derivative work but still use copyrightable pieces. But if you did a work that used pieces that you created from other people's ideas, then that's fine. Okay? In fact, that's not even considered a derivative work because you created all of those pieces. So you can do a painting of the Mona Lisa if you want. I mean, good luck, but you can do that exact painting and expression. And I mean, if you can create that digitally and make it look exactly like that, that is your work. You have every right to do that. So it got very, very touchy once we got into programs like Photoshop. Once we got into the digital realm, things were getting, really messy when it came to that. Okay, so now that we're kind of clear about what copyright is and what copyright infringement is, remember, I want to keep this kind of positive in the sense that you own the copyright anytime you create a work. So put that circle C underneath. And if you take a picture, you can watermark it and say, this is mine. Okay, let me close this out. I'm going to play some excerpts. Also on the assignment here, not the assignment, but the Zoom lecture here. After I post this video here, I do have a link here that's from a communication arts article. And the article is called, "Is it true that copyright doesn't protect graphic design?" Click here. So if you do click there, you'll come to this, and you can read further about copyright laws and copyright infringement as it pertains to graphic design. And I think it's important for us to at least have a basic knowledge of what we should and shouldn't do, and then, take it from there. The touchy part is when you're working for someone that is violating copyright law. And that's a decision that you're going to have to make in terms of whether or not you want to work for, this type of company. I got into a situation like that at one point where the guy was, my superior was saying to snatch photos, stock photos, and you can't do that. You can't do that. And I was very uncomfortable doing that. And yet my job was on the line, and it's this like really hard ethical situation to be in. But hopefully you'll do the right thing if it comes to that. A lot of people today just are blatantly disregard laws of copyright. And, maybe it's a cultural thing, because that can come into play too. If people come from different countries, the laws it's the wild, wild west out there. And they come here, they start a business, they hire you as a graphic designer, and they say, just do this. I don't care what it is, just copy this, just, rip this off. All they're concerned about is the money. So that becomes a very ethical question that each individual is going to have to deal with. Okay, so anyway, you can check that out if you're interested. The video I want to go to is, I did put this up. A cease and desist letter is a document sent to an individual or business to stop allegedly illegal activity and to not restart it, which is what desist means. The letter may warn that if the recipient does not discontinue specified content or take certain actions by deadline set in the letter, the party may be sued. And we had a situation actually at Platt College. I'm not going to say who was involved, but there was a situation where we had an outside job come in. The instructor was asked, do you have a student that would do this? The student did it. Fortunately, there was copyright infringement in one of the images that was used. The client was happy with the work, and then a cease and desist letter was sent to her from the company that owned the rights to it. She called Platt College and said, hey, your student, now suddenly it's your student. Everyone starts pointing the fingers, man, when lawsuits come down. And said they used copyright infringement. I got this letter. I can't use this logo. We already had it printed on our stationery. You need to pay us for the cost of reprinting. It can get like that, okay? Literally. If there's expense involved, and I don't know, Chris, in your business, if that's ever happened to you, or Lauren in your dealings with companies or clients, but that's the danger, especially once that logo or piece is printed, thousands of copies and widely distributed. You got to really make sure that doesn't happen, because that expense, you might not go to court, but just the expense of having to reprint all this stuff could be tremendous. So anyway, this is a video called Ripoff versus Inspiration. And the guy that's giving this is, I don't know much about him, but I just found this on video, on YouTube. And I thought he had he gave a lot of good case studies. So I want to just kind of show a few of them, very, not long. But the first one is, let's see, it's at 120. So let me go there. Okay. And this one is a work of art that was done by an artist that does like art for games, for gaming, something like that. And he did this work of art, and a Ford dealership literally ripped off his work and used it for an advertisement for their dealership. Now, it wasn't Ford corporate, it was some dealership somewhere, I don't know where. But anyway, here's the story.
Not only what is right and wrong, but also outline how that happens because it can become a gray area. And it's important that you, as a designer, are able to recognize when this stuff is happening and what you can do to try to stop it from happening, or perhaps put a different spin on it, change the work up enough, all that fun stuff. So right here I have an illustration done by Ollie Moss, and this might look familiar if you're familiar with the game Firewatch, but even if you haven't seen this particular graphic before, odds are you've seen a lot of people mimicking this style, mimicking this overall color palette, a generic forest in the background with the sunset colors in the background here. A ton of people have emulated this style in a way that is at best inspired by it, and at the worst is just ripping off this design in general. And I'm not saying that the idea of a silhouetted forest is maybe the most unique or perhaps original thing you could possibly do, but once you get too many elements in here working together, like the forest, the way they're kind of tiered out like this, the exact color palette, then you start treading on some pretty dangerous waters. So to show you the next example is someone who just
Okay, so I want to stop you here for a sec. Now he's making he's kind of insinuating that if you created a work of art that's similar to that, that's kind of walking on, standing on shaky ground. That is actually legal. Okay, and I want to clarify the fact that you can make things that look like other things as long as you make them. Okay, so we can't get into this whole idea of similarity because that's really not the issue at this point anymore.
blatantly ripped this design off. So here is a promotion from a Ford dealership, and this is an individual Ford dealership, not Ford, the huge company. So it isn't really Ford's problem as much as this individual dealership's problem. But as you can see, they just straight up ripped off the design. And this is a very clear-cut example of this is totally wrong, and you cannot do this. Just to go back to the original design right here, you can see this is the main layout, and that this is the layout that Ford dealership came up with. It's an exact clone, it's an exact copy. And you can also see that overall this is ripped off pretty well, if you can really say something like that. Like the text seems to fit the overall vibe of what's going on here. They trailed it down in a way that is sensical. So I don't feel like I can say the person who did this was just completely like not a designer, not experienced. They knew what they were doing, and they likely knew what they were doing was totally wrong.
Okay, so I'm going to stop this one here. So this is an example of using exactly verbatim somebody else's work. This is flat out copyright infringement. And this is, something that you cannot do. They would have to take this ad down. Now, there is also an issue of whether or not it's been seen already. And that could be part of lawsuit damages. In other words, it's been exposed, it's been seen. And then to try and recoup any kind of revenues that were generated because it was seen. And that becomes very gray. You can see how complicated that issue might be. But in any case, he also kind of mentioned the fact that it looks like somebody that had some knowledge of graphic design actually did this because of the typography layout. And, this wasn't done by a rank amateur. That has nothing to do with it. Okay, it doesn't matter whether you're just starting out in graphics or you're an experienced graphic designer. The law is the law. Okay, no matter what. You run a red light, you get a ticket. No matter who you are. Okay, so he's making some comments here that I don't want to be misconstrued as, being conditions to it, but I'm sure lawyers would argue these points in the court of law. Okay, let's go to the next one, and that's at 6:37. So let me get here. Okay.
Puts his own spin on it and makes it something original. So I'm going to put this post back to normal size here and check out these posters. So for the game Firewatch, Ollie Moss made these 3 different posters as a limited screen print in order to both promote the game. These posters are, I think, inside the game on the walls of some of the buildings in the game. I'm not sure. I haven't played through the game myself, but I'm pretty sure I remember seeing these on a wall inside the Firewatch Tower when I watched someone else play it. So as you can tell, these are super well done posters that give a bit of a vintage vibe, but still look modern when you look at them, and it also shows really strongly just how good of an illustrator Ollie Moss is. So these posters and this style is actually a very well documented style from America's national parks. They had a large campaign of posters in order to promote the parks. The one that stands out most to me is Yellowstone. So these were heavily inspired by those posters, but are in no way a ripoff, not even close to ripoff, because he did a great job of putting his own spin on this. But I have some of these posters here for you just to check out so you can kind of see what I'm talking about. So things to take a look at here are the muted palette of the colors used, the painterly illustration style, which if you compare this to this, you can start to see some similarities in terms of the overall styles and the execution of those styles that were made. And I'll just keep going through a few different examples here so you can kind of see what I'm talking about. So if you compare this image of this poster that I think is a really great poster in its own right, although it looks and feels very dated now, compare that to what Ollie did, and I'll find the one with the deer because I think that's a really close and good comparison between these two. What Ollie did is completely inspired by these posters. It made me think of these posters immediately when I saw his original work, but at the same time, his work is definitely his own. It's completely new content. It has an original spin on it that just makes these feel much more modern than these posters that I think are from like the 20s, 30s, or 40s. I don't remember when exactly these were made. But comparing the two, you can tell that this one right here is much more modern. And in this case, I actually prefer the ones that Ollie did. I think they're just incredibly well done. But that's a great example of inspiration and not theft or a ripoff, because this is a completely original work here, and it's inspired by, it takes elements from, and it is really informed by some of the choices in these posters, but in no way did it just steal design assets from them. It wasn't just minor reworks or tweaks to existing work. It was a completely new and awesome thing. And that
Okay. So I think the main takeaway here is the fact that style, a lot of the terms that we use as artists, style, the look, the feel, of something is not a copyrightable, issue. You can do things that have that same look. And this is an illustration style that has been around for quite a while, and many illustrators have, I particularly love this style too. Very graphic, very, simplified, and fine to do in anything that you think of. So again, the idea of, and he's also expanding upon the point that it's different content. Not really sure that it's that different of content, but for the most part, it served a different purpose, is what I think he's trying to say. This last example that I want to show is one that I just mentioned about kind of getting into a sticky situation where you're being asked to kind of do something, or your job might be on the line, or, this is a much more fast-paced type environment. And what this person here is saying is that a lot of times when you're working for companies that have very quick turnaround, it's like we got to get all this stuff out. That's when designers get kind of pressured into copying stuff and ripping stuff off, because they just don't have time to make this stuff up. I mean, you guys know how long it takes to do an illustration, and that's fine if you have all the time to do that. But if you need to get 5 of these things done by the end of the day, then that's when you start kind of going down this dark path and going, well, shoot, I'm going to get fired if I don't get all this stuff out. So I'm just going to grab this and grab that, and hopefully no one's going to even notice. The example here is of the company Zara. And let me just get to this here, and we can see what this story is about.
a complete ripoff. But basically, there's an artist named Tuesday Basson, or Basin, I'm not sure how to say her name, that had a ton of her work knocked off by a company called Zara. And Zara's defense for this is what really made a lot of people mad, because large companies like Zara stealing individual artists or illustrators' work isn't that uncommon. It happens quite a lot. Oftentimes, these companies will hire design companies who will then in turn place those crazy restrictions on time onto their designers, who are then forced to kick out work really fast, which means they have to essentially steal the ideas to make it happen. So Zara's argument here is the lack of distinctiveness of your client's purported designs makes it very hard to see how a significant part of the population anywhere in the world would associate the signs with Tuesday Basson. And that sounds like one of the most dicky things you could possibly say to someone. Like, no one's going to know that your artist made this work, and therefore what they did is irrelevant.
You know, and that's what corporations do all the time, and they're lawyers. In other words, we are Zara. We eat you for breakfast, and you're nobody. And so whatever you do, we can take because nobody even knows who you are. I mean, you're a speck on the map. And, unfortunately, what he's saying in this is that does score points, and that is taken into consideration. The exposure factor, what what your exposure is versus someone like a giant company like Zara. The interesting thing about this, though, is that companies like Zara will be very quick to send you a cease and desist letter if you took something of theirs. I mean, on the one hand, they're saying you're a nobody, but the next thing their lawyers are out there trying to pinch you for taking their stuff. Well, if you're a nobody, what's the argument there? But they do that all the time. Disney does that. All the big companies, Apple, Google. I mean, they have divisions that are out there just trying to find copyright infringement that's being used. And they're sending these letters to just ordinary people that really are no threat to them. But again, the law is the law. That's the whole point. Okay, let's go on and just hear some of this nonsense.
And the thing is that this is an actual legal defense to some extent. Like what Zara was saying isn't just complete arrogant craziness. Essentially, when it comes to design and illustration and protecting your design and illustration, is that your work has to be unique enough, it has to be identifiable enough as being yours and not just some generic element in order for you to protect it. So for example, if I drew a really cool triangle, and then I saw someone else also use a triangle in their design, I couldn't tell them to cease and desist using that triangle because triangles were my thing and no one else can use triangles. Triangles as a thing are way too generic for me to protect. They're way too generic for anyone to protect. And because of that, everyone who wants to use a triangle can use a triangle.
Okay, so in that sense, even though you did create it, it's not copyrightable because the object that you created is just too ordinary, too general. And that goes with a lot of things. Look down here at this photo, okay? This guy's large face, sitting in the corner of that. That's a style that is just too generic to copyright. You can't copyright that. You can't copyright the style that it was photographed in. So that's, again, adding to a lot of the gray area that is part of copyright infringement. But basically the rule is that generic objects and things like circles, triangles, and squares and layouts, basic grid layouts, headline at the top, photo in the middle, those things are not copyrightable.
Some of these examples, you look at this like a heart-shaped lollipop, and it's pretty darn clear as you look through all of these examples that this was a blatant theft of this person's, or at least knockoff. I think knockoff is a great word for it, of this person's work. But as an element, a heart-shaped lollipop or sucker is just not that unique of a thing. So that's where Zara's legal defense sort of comes into play here. But once you see the fact that they took all of her work and knocked it all off very closely, it becomes much more clear that this isn't an isolated incident. If this just, for example, just this heart-shaped lollipop was the only thing they took, it might have been just a coincidence, something that happened. But there's way too many of these for that to be the case. And in this case, Tuesday has a much stronger case against Zara because it was such a blatant copy of entire concepts that were already established. And some of
Okay, and so the point here is that what lawyers are looking for is intent. That's the key here. The intent was to rip her off. They copied all of her work, or a lot of versions of her work. So their intent was to do that. It wasn't a one-off situation. And so again, score points for Tuesday Basson.
these two that become even more tricky are something like this keep out little diary or book right here, where the Zara knockoff of this keep out is a different illustration. It says different stuff on the cover. It uses different colors. So any one of those differences wouldn't really be enough to protect Zara in this case, but all of them put together do make this, figuratively speaking, a unique illustration as opposed to this one. So once again, if this was the only one that they knocked off, they'd be in a much better place. But because they ripped off so many of these different ideas, it becomes extraordinarily difficult for Zara to defend what they did. And I've literally worked at places that worked for places like Zara, like an Urban Outfitters, both of whom are known for just stealing other people's work. And like I said before, how that happens is you'll get a stack of designs. They'll provide you with references about how they want that style to look, how they want that artwork to look. And if you aren't super, super close, your business is not going to get the work. They'll just pass you off for someone else, because largely, for the most part, these places work on spec or speculative design work, in that your agency or the place that you work won't get paid unless they accept the designs and push them through. So
Okay, work on spec. That's another issue that we all face a lot of times, even more so today. Simply, I'm not going to pay you unless I use it. So I want you to design me all these ideas. I'll look at them. If I like some of them, I'll pay you for them. If I don't pay you for them. And what we were always told, always, and for me, this is something that I highly stress too, is do not do work on spec. Okay. I know you might be needing the cash. You might be, it might be an opportunity. They'll tell you things like, oh yeah, if you do some good designs for you, we got a lot more where that comes from. And there's a possible, full-time employment opportunity here too, if it really turns into a good thing. But we have to, as designers, we have to stand up and fight for our rights, and just the rights of anybody. I mean, I don't know anyone that would do work on spec. You don't go into an auto mechanic with your car and say, you know what, why don't you fix my car, and if it works, I'll pay you. I mean, no, it doesn't work that way. You get paid for the work that you do, whether they use it or not. That's up to them. And that's why you have a portfolio. And that's why your portfolio is basically your track record of what you can do. This is proving to you that I can do what you want me to do. But it's not about, I do the work and then whether you like it or not, you pay me. So, but unfortunately, like he says, that's the way a lot of these big companies work. And there's people out there that work on spec. And so it makes it, it's not like I have an answer for that. But I say ethically, and as a business person too, you might get into the situation one day where you have your business and you're hiring designers to do that. And so don't do that, to them either. The ethical thing to do is to pay someone for what they did. And whether it works out for you or not, that would be your mistake in hiring that person, if you weren't sure that was the person that can do the work. So you need to be, you need to scrutinize it a little bit more. Okay, so that's kind of, some ethical situations that involve, uh, you know, not only copyright infringement, but being in these situations where you're being asked to infringe on copyrights. And I think in the end, when you're sitting in an interview and you're across the table from someone that's about ready to hire you, and they look at you and they say, "Do you have any questions for us?" This is definitely a question that I would ask. You know, what is your feelings on copyright infringement? You know, and you might see their jaw just drop on that. But if it's an ethical company, then they'll come right out and say, "Oh, we don't ever do that here," and that's a good thing to hear from a company. If they can't answer that question right off the bat, then that's something that you might have to be dealing with if you work for that company. Anyway, this video's up here. There's a lot of conversation about this topic of business ethics in all walks of life. But basically, it's what should you do when faced with a situation like that. So I wanted to talk about that today, and in our next lecture, I want to talk about pricing. I want to talk about charging for your services. Not just what do you charge, but what is it based on, and what are ethical things about pricing? Because that can get quickly out of hand, and we're constantly being asked to do more a lot of times than what was originally, what we were originally being paid to do. More versions, more revisions, things like that. And when does it become ethical or non-ethical to institute, your policies on that? And there's ways to prevent that right off the bat, and that's what I want to talk about. Is a lot of this has to be discussed way before you even lift a mouse or lift a pencil and start doing anything. Before you turn the creative switch on in your brain, you've got to know what the monetary situation is. And that's probably the biggest mistake that we all make is, number one, not knowing how much we should charge, and two, not enforcing a policy that that deals with those issues in terms of contracts, in terms of payment schedules, and all of those things. A lot of times we just do it by the seat of our pants. And what ends up happening is we get stiffed and we don't get paid. Or we end up putting in a lot more time than we're getting paid for. But then there's another issue also. And a lot of times we put in a lot more time, not because we're being asked to do it, but because that's just us. We're perfectionists, and we end up spending 10 hours on something that should only have taken us 2 hours to do. But we're such perfectionists and we want to do that. Well, that's our own fault. And anyway, we'll talk about those things. Okay, so that is my lecture today on ethics, on business ethics. I didn't talk about Prepress. I will talk about Prepress in our next lecture a little bit, but I'm having kind of some some mixed thoughts about the idea of spending a lot of time in Prepress. Prepress, as far as file preparation is concerned, I think it's very important that we all know how to prepare our files. But Prepress really is a function of the printing company. They do a lot of prepress, and I'm not sure how much involvement you're going to be in the print industry in terms of doing press checks and things like that, and really knowing how to interface with pressmen, and but it's part of our curriculum, and it should be covered. So okay, so that's all that I have, and I will meet with you guys again on Monday and for more marketing stuff. So Okay, I will
All
see you
right.
guys then. Okay, take care.
Then, bye.